We will go through the steps involved in the trial of warrant cases by magistrates in cases instituted on a police report where an FIR has been registered. Now, what is a warrant case? Warrant case means a case relating to an offence punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years. So as a general rule, we could point out that the cases or offences where the term of imprisonment is greater than 2 years are warrant cases. The criminal proceedings are initiated by giving the information regarding the commission of an offence to a police officer, that is, by lodging an FIR. What we know as an FIR is CRPC Section 154, which is Information in Cognizable Cases. What are cognizable cases? They are the cases or offences in which a police officer can arrest without a warrant. Here a warrant does not mean a warrant case. It means an authorization by a magistrate. So, the cases in which a police officer is not required to obtain authorization by a magistrate to make an arrest are cognizable cases. So, an FIR is only registered in case of cognizable offences. Now, whether an offence is cognizable or not is mentioned in the first schedule to the CRPC. Now that the FIR has been registered, the police will begin investigating the case. Investigation includes all the proceedings conducted by a police officer for collection of evidence. CRPC Section 156 provides for the power of police officer to investigate cognizable cases. CRPC Section 157 provides for the procedure for such investigation. Examination of witnesses and their statements are taken under CRPC Section 161. And if the police officer has to conduct a search of a place, it is done under CRPC Section 165. After the investigation has been completed, a report is submitted to a magistrate. This is known as a police report. This police report is submitted under CRPC Section 173, subsection 2. The police report is also referred to as a Challan or a Chargesheet. In different circumstances, a cancellation report, a closure report, an untraced report, or an undetected report may be filed. Now that the police report has been filed, the trial has yet not begun. It would begin only when the magistrate would take cognizance of the offence. Here, cognizance means to take a judicial notice. Now, this judicial notice by a magistrate, that is the cognizance by a magistrate on a police report, would be taken under CRPC Section 190, subsection 1, clause B. The very first step after the cognizance of an offence has been taken is to supply to the accused the copies of documents. Here, the magistrate will make sure that he has complied with the provisions of CRPC Section 207, under which a copy of the FIR, a copy of the police report, statements under CRPC Section 164, the statements under CRPC Section 161, etc. are provided to the accused. Now an opportunity of being heard would be provided to both the sides, that is, the prosecution and the accused. After hearing them, either of these two could happen. If a magistrate considers the charge against the accused is groundless, the accused would be discharged under CRPC Section 239. If a magistrate is of an opinion that there is ground for presuming that the accused has committed an offence, the magistrate will frame charges against the accused under CRPC Section 240. After the charges have been framed, those charges would be read over and explained to the accused. Then the accused shall be asked whether he pleads guilty or he claims to be tried. Now, if the accused pleads guilty, he would be convicted under CRPC section 241. If the accused pleads not guilty, or he claims to be tried, or he does not plead, the stage for evidence for prosecution under CRPC section 242 would begin, and the prosecution side will examine their witnesses and the side of the accused shall cross-examine them. After the stage of evidence for prosecution is over, the accused shall be examined under CRPC section 313. The purpose of this examination is to enable the accused personally to explain any circumstances appearing in the evidence against him. This examination is done by the magistrate, and no oath is administered to the accused when he is examined under CRPC section 313. And if the accused gives false answers in this examination under CRPC section 313, he shall not be rendered liable to punishment for giving such false answers or for refusing to answer any question. After such examination, the accused shall be given an opportunity to produce his evidence. The accused can also apply to the magistrate to issue summons to witnesses to compel their attendance. The accused may also stand as his own witness. Under CRPC section 315, the accused is a competent witness, but if he chooses to stand as a witness for himself or for other accused, his examination would be under oath, and he shall be liable for punishment for giving false statements. The accused can only be called as a witness upon his written request and not otherwise. If the accused does not step into the witness box, no adverse inference against him shall be taken. After the evidence for defense is concluded, both the sides, that is, the prosecution and the accused, shall address oral arguments to sum up their respective cases. There is also a provision under CRPC section 314 for submission of written arguments. Now, after considering the arguments and all the matter that has come on file, if the magistrate finds the accused not guilty, the accused shall be acquitted under CRPC section 248 subsection 1. If the magistrate finds the accused guilty, the accused shall be given an opportunity of being heard on the question of sentence. Then after considering that, the magistrate shall pass sentence under CRPC section 248 subsection 2. The accused may also be released on probation under CRPC section 360. Now it is to be noted that the magistrate of the first class has the power to inflict punishment for a term up to 3 years. Now, if the magistrate thinks that the accused ought to receive a punishment more severe than he is empowered to inflict, then the magistrate shall forward the accused to the Chief Judicial Magistrate under CRPC section 325.